So, the term winding up of a company may be defined as the proceeding by which company is dissolved. That is, putting to an end is known as winding up. Putting to the end of the company is known as a winding up of a company. So, winding up is the process of dissolution of a company. It is mainly carried out by the company liquidator. It is mainly carried out by the company liquidator. So, here during the winding up, the company is dissolved. In the course of such dissolution, the assets of the company are collected here. Debts are paid off out of the assets of the company or from the contribution by its members. If any surplus is left, then it is distributed to the members by the following their rights. So, here the term winding up of a company is nothing but dissolution of a company, that is putting to the end of the company is known as a winding up. So, it is the process of dissolution of a company. So, during the winding up, what they will be taking into the consideration, the assets of the company are collected, debts are paid off of the assets of the company. If any surplus is left, it is also distributed by their members according to their rights, is known as winding up of a company. So, during the process of winding up, the company remains still and has a corporate powers until the company gets dissolved. So, company till the end of the company is winding up, closing day, till the closing day, the company will have full powers, corporate powers will be there until the company last day it is dissolved. So, it means winding up is the initial stage and then comes to the dissolution. At the time of dissolution, the existence of the company comes to an end. The name of the company is not struck off from the register of companies of the winding up. Therefore, there exists a legal status of the company in between the winding up and dissolution, where it can be used as a tribunal of law. So, here this is the meaning of this winding up. Now we are going to discuss about the definition of winding up. According to the Professor Gover, winding of a company is the process whereby its life is ended. Where the process where the life is ended and its property is administered for the benefit of its creditors and members. And the administrator is called as a liquidator. Administrator is called as a liquidator. Is appointed and he takes control of the company, collects its assets, pay its debts and finally distribute any surplus among the members in accordance with their rights. So, what is the definition for this? Winding up is nothing but company coming to the end. So, at the time of winding up, what they have to do? A liquidator or administrator will collect all the assets, and if still any more debts are there, even still more any debts means if any thing if you want to pay to the others, the liabilities whatever is there, sell these assets and you pay them. Whatever is left out after selling, whatever you got, you pay the debts. After paying the debts, whatever is left out you distribute among yourself, is known as winding up. Got you clear, students?
Yes, ma'am.
Yeah. Thus, the winding up is a process of putting an end to the life of the company. Winding up, how if a person is died, we will be saying expired. In the same way, company also putting the life to the end. Company is coming to the end, then we will use the word is winding up. In point of company point of view, we will be using when we are closing a company, the name for the company when you are closing is called as a winding up of a company. And During this process, the assets of the company are disposed. Just now I said that whatever the debts of the company are there, it will be paid out of that realized assets. Whatever after selling the assets, whatever the amount you got, that will be from that contribution of the members, taken some of the amount and they will pay back the debts. After paying that, any amount is rest of the remaining, they will distribute the members as per their rights. Whatever the investment they have invested, as per the rate, as per the rights, they can distribute their amount, whatever is left out. So here, the company is dissolved by an order of the tribunal. So simply whenever you want to close, you cannot close, you have to take the help of tribunal, that is as per law you have to close. Some rules and regulations will be there for closing up of the company also. So until the company is dissolved by the tribunal order, it remains taxpayer. So compulsory you have to take the permission of the tribunal, then only you can dissolve the thing, otherwise you cannot close your company. Now here, what are the two modes are there for winding up of a company? So the following two types of the modes are there for winding up, as specified in section 270 of the Companies Act 2013, that is compulsory winding up, and the second one is voluntary winding up. Compulsory winding up is nothing but that is winding up by the tribunal, that is as per law. Voluntary winding up is nothing but without intervention of the law, you are you are taking the initiative and you are trying to close the company, is called as voluntary winding up. Means voluntary means you are coming forward to close that company and then you are giving the information. And compulsory winding up is nothing but when the company is very in sick position, the company is unable to run the company, there are so many debts. In such situation, there is no chance to run the company. That time you have to compulsory, you have to wind up. But if you want to wind up, very big tough issues are, then definitely you have to rule out the company or close the company. You have to take the permission of the law. As per the law only you have to close the company. Sometimes we voluntarily come forward and all the whoever are the partners are there, they will come forward and you people will discuss and you will try to close the company. That is voluntarily. Voluntary is nothing but you know that they are coming forward and you voluntarily taking initiative without intervention of the tribunal, you are coming for closing, is known as voluntary winding up. Compulsory winding up is nothing but winding up by the tribunal, is called as a compulsory winding up. So the powers to order winding up were earlier vested in the court. As per the court only you have to close the company. If you want to close or if you want to end the company, you have to take the permission of the court, then only you can close the company. Now these have been vested the tribunal, to be known as National Company Law Tribunal will be there. National Company Law Tribunal, which is to be constituted under the 408 of the Companies Act 2013. On the commencement of the new act, these powers would be exercised by the tribunal. So as per the tribunal only, some text will be amended, some rules will be amended. As per that only you have to close the company. That is known as a compulsory winding up. So here, what do you mean by compulsory winding up, and what are the this will be very why they will voluntarily, why the company will compulsory winding up, why the law will take initiative to close the company, what are the reasons, we will see now. So the winding up of a company by an order of tribunal is also called as a compulsory winding up. Just now we have discussed that. What is a compulsory winding up? Compulsory winding up is the winding up by the tribunal, is known as a compulsory winding up. So here also I am saying the winding up of a company by an order of the tribunal, means the tribunal should give the order to close the company, then it will be called as a compulsory winding up. So here section 271 of the Companies Act 2013 contains, which the company may be wound up by the tribunal. The tribunal may be wound up by the company on a petition submitted to it to any of these grounds. So the powers of the tribunal to order wind up on these grounds is discretionary. The tribunal is not bound to make an order of winding up. So section 271 of the Companies Act 2013 has deleted 3 existing grounds for winding up. namely default is providing statutory report to the registrar, or default is holding statutory meeting, failure to commence business within 1 year of incorporation, a business, the affairs of the company have been conducted in a fraudulent manner. If you are not doing your whatever the activities of the company or the affairs of the company in a proper manner, if you are doing any fraud things in your company, and the company was formed for the fraudulent and unlawful purposes, any you are not following the rules of the law and you are ruling your own way your company, in such situations a compulsory winding up is very very important. So what do you mean by compulsory winding up? Just now I said wind up by the tribunal. Tribunal is means what? The winding up of a company by an order of tribunal is called compulsory winding up. Means as per law, as per rule, you have to close the company. In what situations you will close the company? If you are not running your affairs of the company in a proper manner, so the tribunal will have every right to close your company. If you are doing any fraud things in your company, then also they will have every right to close your company. And unlawful things, if you are doing anything in the company, that also they will have every right to close the company. So the persons concerned in formation of a management of the company have been guilty of fraud, misfence or misconduct if they are doing in management point of your administration, if they are not doing proper as per the rules, if they are not doing, then anytime they may have a right to come and the tribunal will come and close your company. So that is known as a compulsory winding up. At what situations you will close means the affairs of a company have been conducted in a fraudulent manner, the company was formed for fraudulent and unlawful purpose, if they are doing, they will have every right to close the company. The person concerned in formation of a management of the company have been guilty of fraud, misfence or misconduct if they are doing, they will, all the grounds of circumstances for winding up of a company, in such situations they will, compulsory winding up will be possible. And also company's inability to pay its debts. If the company is trying and trying but they are unable to pay the debts of the company, so it will becoming a more burden to the company. The company will be coming to the very dangerous situations they will be coming, because too many debts have increased for the company. So in the compulsory winding up, the tribunal will come and close the company. If the company is unable to pay its debts, then the tribunal may have give order to the winding up of a company. Still more, don't put you are borrowing from outside and you are putting in the company, still you are getting losses, again you are borrowing, and how many times you will do, they will refer, they will check it this, but still your company is not in a growth stage, definitely the court will take an action and they will only close your company. So if the company is unable to pay its debts, then the tribunal may add order in winding up of the company. The term debt means here definite sum of money which is due, and immediately you have to pay that money, but you are unable to pay that money to immediately, then that situations payable by the company, but the company is not unable to pay the money to that conditions also, you will have every right to close the company. So the term inability to pay here means company's inability to pay its current liabilities. Whatever the debts are there, whatever the liabilities are there, you are unable to pay that liabilities and you are unable to pay that debts. In such situations, when they arise in the ordinary course of business, thus inability to pay the debts is to be taken as commercial sense. But the test of inability to pay debts therefore is whether the company can pay its existing liabilities, so long as they will give some time. If they are not paying, so definitely if the company cannot run in the as we know that going concern concept, all that, if the company is not in a position to meet its existing liabilities, so many liabilities have increased, how much they try also they are unable to solve that problems and pay that liabilities, so immediately a petition for winding up is maintainable, even if they have very valuable assets not presently reliable. So just they will unable to pay that debts. In such situation, whatever the company, there is only one option to close the company. In such situations, if they are unable to pay the debts to or liabilities to the who wants to pay to the means company is unable to pay the liabilities and debts to the unable to pay, in such situation they will have only option just to sell the assets and they pay back the debts. There is only one option. In such situations, a compulsory winding up is at the tribunal. The law, the court will take action, and they will come forward and they will see what are the assets of the company. They will put in an auction and they will sell off that assets, and they will pay back the liabilities and debts, and still anything amount remaining they will share with their members. Whatever the whoever is invested in the company, all the members will share the rest of the amount whatever is after paying the debts. Got you clear, students? Are you getting? Hello?
Yes, ma'am.
Yeah, good. Okay. And next, at what situations they will do the special resolutions by the company? So, if the company passes some special resolution to the effect that company can wound up by the tribunal, then the tribunal may order the winding up of a company on a petition, that is, a application presented to it by the company or contributory. So, special resolution by the company. If a company passes a special resolution to the effect that the company be wound up by the tribunal, sometimes they are unable to solve that issue. They will write some resolutions they will take, and they will issue the closing of the company, wound up the company. Then the tribunal also will give, the court will say that you close your business, and you should write one application presented to it by the company or a contributory. So you have to write that you have to close. There is only one option. We cannot solve the problems. The problem, if you want to solve it, the only solution for that problem is to close the company, sell the assets, pay the liabilities. Whatever the amount is left over, please share with among yourself. So it is important to note that passing of special resolution by the company itself is ground for presenting a petition to the tribunal, and no other ground is required for presenting the petition. So, thus winding up of under this clause is maintainable simply if the company passes a tribunal. However, tribunal is not bound to the order wind up of the company. So, acting against the interest of sovereignty and integrity in India. So, the sovereignty and integrity of India, the security of the state, the friendly relation with the foreign state, and the public order, decency, morality, then the company may wound up by the tribunal. So, why we have to close the company? You may ask the question. For the security of the state, still the company should not be losses. And it is important note here that on this ground, the application or a petition for winding up can be made by the central government or state government as per sections 271 under section 1G. So, company becoming a sick, when you, or what are the, at what situation you will close the company? Company is becoming a sick. Just now I said that if the company has become a sick company and its revival is not feasible, you cannot sustain that particular company because the company is in more and more losses. In such situation, who will come forward? Who will give the order to the whom? If a company is becoming a sick, who will give an order to whom? Hello? If the company is becoming a sick company, who is giving an order to whom to close the company?
Tribunal, madam.
Yeah, exactly. Very good. Tribunal is giving a order to whom? To the company it is giving. So, yeah, in that finding out that order, winding up of the company will be possible. So, and the next point is conducting company's affairs in a fraudulent manner. If it is a new clause providing 3 new grounds for the winding up of a company by the tribunal. If the affairs of the company have been conducted in a fraudulent manner, in such situation the company will close. Just now I said, if the company is becoming a sick, you will close. And if the company is not following the rules and regulations, that time also the tribunal will have every right to close the company. So all these are the if they are not running management functions, if they are not doing properly, also in such situations also the company will become a close. And default in filing financial statements or annual return, they are not maintaining properly. If the company has made a default in filing with the registrar its financial statements or annual returns for immediate proceeding of 5 consecutive financial years, the company may be wound up by the tribunal. So compulsory you have to file the financial statements or annual returns, you have to show to the registrar of company. If the company has made a default in filing, they are not filing the financial statements or annual returns, if they are not doing properly, then definitely within 5 years period they will observe. And if you are not filing proper financial statements, then definitely the company will be in a wound up stage. So here compulsory winding up is here. The winding up of a company shall be deemed to commence from the time of the presentation of the petition and not from the date of winding up by the tribunal. But where before the presentation of winding up, first we have to provide presentation, then they will give some date. On that date only you have to close the company. Next comes under and what are the powers and duties will be there for winding up committee will be there. The concept of winding up committee is introduced by the Companies Act 2013 to assist the company liquidator in carrying out the liquidation process. We know that the time of making the winding up order by the tribunal, the company liquidator is also appointed for conducting the liquidation, has been empowered. If you are not administration, if you are not doing properly, also in that situations also the company will wind up. So who is the company liquidator here? A company liquidator is also an officially appointed for the purpose of winding up of a company. A company liquidator is also an official appointed for the purpose of winding up of the companies. Section 2 under Section 23 of the Companies Act 2013 defines the company liquidator as under: company liquidator in so far as it relates to the winding up of a company means a person appointed for the company liquidator by tribunal in case of compulsory winding up, the company or creditors in case voluntary winding up. Thus, in case of compulsory winding up, company liquidator is appointed by the tribunal to close the company. Who will appoint this company liquidator? Tribunal will appoint. Who is the tribunal? Court will appoint some liquidator to see the matters of the company, what are their financial statements, give the order to they will give the administration process, just check it and tell the information to the tribunal. So appointment at the time of winding up. At the time of passing of winding up order, the tribunal shall appoint either an official liquidator or a liquidator from the panel of professionals maintained by the central government as company liquidator. So who is the liquidator? At the time of passing of winding up of an order, the court will appoint the liquidator from the panel from the central government as a company liquidator to look all the matters of the company. While passing a winding up order, the tribunal may also appoint a provisional liquidator if already appointed by it. So, the company liquidator for the conduct of proceedings, what are the proceedings are there to close the company, also will be looked after by the liquidator. On his appointment, the company liquidator shall file a declaration in the prescribed form with the tribunal, disclosing the conflicts of interest, what are the conflicts, what are the problems of the company, everything he should be in a position, he should give that. So, it's to be filed with the tribunal within 7 days from the date of appointment. On the appointment, the company liquidator shall file a declaration in the prescribed form with the tribunal, disclosing the conflicts, what are the problems. If any such declaration is to be filed with the tribunal within 7 days after appointing, he should check it within 7 days date of appointment. He should start the checking of all the matters of the company. the terms and conditions of appointment of a company liquidator and the fee payable to him shall be prescribed by the tribunal on the basis of task required to be performed, experience, qualification, size of the company, everything will be looked at. So this is about the company liquidator. And still what will be there in the last unit? Yeah, voluntary liquidator. I'm telling the full topic about the fifth unit is mainly what do you mean by wind up, what are the modes just now I discussed, fifth unit. And in the fifth unit next topics is voluntary winding up, closing, compulsory winding up. These are the things will be there in the fifth unit. So now we are going to discuss just the what are the compulsory winding up one. Voluntary winding up means what? At what situations they will do voluntary winding up, I'll discuss with you. So this is very important chapter. In this you can expect 2 questions from 5 for your final. So just generally they'll ask you what do you mean by winding up, what are the modes of winding up, very important question, what are the modes of winding up, and they may ask you what do you mean by voluntary winding up, compulsory winding up. So these only questions you may expect. Mostly they'll used to ask in the exams, the important in this topic. Okay, so today you read off these 2 questions, 2 to 3 questions what I said, just you have a look on that answers and complete the syllabus. I'll put you the unit wise, I'll give you the whatever is more important, unit wise also I'll give you. Okay, today I'll share in your groups. Please try to start the revision daily, one unit you try to read off. Okay.
Okay.
Yeah, so almost with tomorrow or within 1 or 2 days the 4 portion will be completed. If possible, just if you want any doubts, if you have, just I'll revise you as a revision if you want anything if you are not done. So by tomorrow I'll post the important questions, so syllabus will be completed. Okay, if you have any doubts in any topics,
Ma'am, we don't have assignment for company law.
you have I said no already, you have to post. Have you assignment you write down?
No, ma'am, we haven't got assignment questions. We done only internal.
Okay, I'll send you some important questions no tomorrow. In that at least 1 or 2 3 questions I'll say you in that near only. I'll put you tomorrow, so write down within 1 or 2 days 1 2 questions you write and bring it out. Okay,
Okay.
important questions I'll share you, unit wise I'll share you whichever is important. So please from that unit, every unit you try to write off one or one questions like that. I'll pick it, I'll tell you which questions tomorrow. Tomorrow only you write it and keep 1 or 2 questions keep aside and okay, from that
Okay.
from the important only you write it, so you will also get perfection when you are writing only. You will try to read off that questions also. Okay, at least 1 or 2 you will
Yes,
do.
ma'am.
Yeah, tomorrow I'll share
Thank you, ma'am.
all that questions. Okay ma?
Yeah.
Yeah, still if any more
Yes.
doubts if you have also, uh, and then again I'll connect in 1 or 2 days. If you have any doubts regarding the subject, you ask any topics, or if you are not getting also, I'll explain you. Also this is the 5th unit, ending up of the syllabus. So I'll call you, I'll whenever anything, if I want to revise also, if I'll get a time I'll revise also, but try to attend it. Most of them are not attending the class.
Okay.
Yeah, so daily unit wise, daily one unit you try to read off. A unit wise I'll share you the important questions. Don't depend only that, to other questions also please try to read. Okay,
Yes,
daily
ma'am.
daily one unit you try to, daily at least 2 units. Tomorrow if I'll share, tomorrow you try to read off 2 units, day after tomorrow 1 unit, and day after, by till Sunday you have to complete the revision also of company law. Which subject is there starting?
Check, ma'am.
Set papers you have. Okay then. Yeah, So, and the next comes under the voluntary winding up. Voluntary winding up is nothing but a company liquidator is appointed in general meeting when resolution of voluntary winding up is passed. He is appointed from the panel made by the central government, and even fee to be paid is also recommended by the company. In case of resolution, the winding up is passed by the creditor, then approval is required for the appointment of such company liquidator from the creditor. So, company is calling the other people, we will close the company. So, in that situations, a voluntary a resolution you have to pass in the meeting, and you have to tell to the panel, so that you have to write some letter to the central government, that government people will send it. After appointment of year, after writing the application, within 7 days the company liquidator must file the declaration in the prescribed form. Even a notice must be given to the registrar about the appointment of a liquidator. Same like that only it will be there. But here company is calling, so and so we are in losses, so please what is the how we have to do, means they will be appointing here a liquidator. Whereas in a compulsory liquidator, the court is coming and doing all that things, everything. Here voluntary means you yourself is passing some resolution, we want to close the company. What are the reasons why you want to close the company? So they will, after discussing, they will appoint, the central government will appoint one liquidator. You have to, same things you have to follow here also. So the company liquidator must carry out the functions and discharge the duties which are imposed by the company or creditors from time to time upon. The company liquidator must call general meetings of the company in order to get the approval from the company through ordinary or special resolution. So the company liquidator must settle the list of contributors which has to be proved the evidence. The company liquidator must make the payment of debts and adjust the rights of the contributor. So here the liquidator will come and he will only pay all the things voluntarily. From that people only they will write some petition and they will call it. That person will come and they will do all that. Here voluntarily these people, company liquidator only settle all the contribution, all the debts, all the liabilities. He will only adjust everything. So the company liquidator also must maintain proper books of accounts regularly in the prescribed manner. These books are verified by members, creditors, or any officers authorized by the central government. So here a company liquidator is appointed in a general meeting. As a resolution, voluntary winding up is passed. Whenever you are trying to close the company, that time only you are in the meeting, you will be appointing, company is appointing a liquidator. So that company liquidator will check it all, that what is the position, whether it is in a position to close or not, how many debts are there, how many liabilities are there, why they want to close. They will conduct some general meetings of the company, special resolutions they will take. Even they will try all the various ways how to not to close the company, but after taking the coming to the liquidator will check all the details, financial status, everything. If they'll check, okay, this is not in a position to solve the problem, so definitely he is the person, he will only pay the debts, he will only look after the matters of all the things. So the company liquidator must prepare the quarter statements of the accounts, everything, statements, quarter what are the problems, everything. The company liquidator must be very careful while discharging the duties, otherwise penalty is charged. So he will be appointed before the company is calling that liquidator, and he will be looking after the things, whether it may be in a possible way or not. So the company liquidator must give a quarter report regarding the process of winding up the company to the members and creditors. He should all call at least one quarter meeting of the members of creditors. If the fails to do so, fine is charged with the amount which may be extended to 10 lakhs also. If the company liquidator suspect any person committing fraud against the company, then immediately he must submit a report to the tribunal. So immediately he will inform any in the company any person is doing any frauds. So if he find out any person is doing any frauds, then immediately he should report to the court without affecting the progress of the winding up. Tribunal must give order to the investigation. That company liquidator must prepare a final report for winding up showing the disposed of assets and debts which are fully discharged, and call final general meeting to submit the winding up accounts. Everything which will be look after by the liquidator here. Liquidator voluntarily, the liquidator will be appointed, so by the company everything will be looked after by the liquidator, and he will solve the problems. Okay, got you clear, students?
Yes, ma'am.
Okay.